Hello YouTube, welcome to my channel. Today we will talk about conflict of laws. As you can see here, I prepared a video for you, especially for university students from different countries, that we will talk about conflict of laws today. To start with the video, first we will mention about conflict of laws. As you can see here, there are different definitions given by different scholars that is attached here. So we will discuss about here. Robert Alan Searle talks about conflict of laws here. As you can see from here, Robert Alan Searle defines that conflict of laws is the body of laws that determine whether the forum will give effect to laws of another state, where the case that is adjudicated contains a foreign element. If there is a foreign element, there must be a conflict of laws. You must understand this. So that the body of law that determines whether the forum will give effect to the laws of another state, where the case that is adjudicated contains foreign element. If there is a foreign element, there is conflict of laws. When does the case contains foreign element? There are three grounds for the case to contain a foreign element. You must understand this for your exam. If you finish this video, you will score A+ as me. So please pay attention. The first ground to say there is a foreign element, the case contains a foreign element. To say the case contains a foreign element, there are three grounds. These are when the event giving rise to the litigation occurred partially or totally in foreign lands, if the case or if the litigation occurred is partially or totally, as you can see here, partially or totally in foreign lands. If there is a foreign land that if the case is arise, or if the litigation is arise in the foreign element, there is a conflict of law. There is a foreign element. The second ground, the first is if the event giving rise to litigation, or if the cause of action is occurred in foreign lands. The second one is when the parties, as you can see here, the bold words, event, parties, and property. The third one, so the parties to the dispute are domiciliary nationals or residents of different states. As you can see here, if the parties to the litigation are different nationals, or the nationals of the two countries, or example, if someone is from China and the other party is from America, then the conflict of laws will occur, or the foreign element will occur. So the third one is the property or the subject matter of dispute. You will see the name property after this time by changing its name to subject matter of the dispute is situated outside of the forum. If it is situated, the property or the thing that you are disputed into is situated outside of the forum, then this will this will contain the foreign element. So the three grounds are: the first thing is the event occurred in foreign lands. The second one is the parties to the dispute are different nationals, and the third one is the property or subject matter of the dispute is outside of the forum. The next thing you have to understand in order to score A+ is nature of conflict of laws. The conflict of laws rules does not by themselves dispose of a case with a substantive remedy. They are only indicators, as means. They are not ends by themselves. They are means that they show where the forum will be discussed or where the issue will be resolved, but they will not give a solution to a problem. But they direct the places to have a solution. They direct procedures or something that will give us a final result, but they are not end by themselves. They are means to the end. They are means. So they cannot dispose a case with substantive remedy. They cannot give substantive remedy, but they direct us a direction. They give us a direction to substantive remedy. You must understand this. And they simply indicate the law through which the final remedy could be obtained. They are indicators. You must understand this. They are indicators by themselves. They are not ends. You must understand this. The second one about the nature of conflict of laws is that it is not concerned with public cases. They are not matter. They have not give emphasis for public cases, especially for criminal, revenue, customs, and constitutional and administrative cases. They are all related with public cases. They are not. Private cases. The name given to conflict of laws or private international law is that it governs or it considers or it concerns about private purposes, not public cases like criminal case. Criminal case, as the name implies, is a public case. Revenue case, customs, constitutional and administrative issues will be administered by public international law, not by private international law. See this. It deals with disputes of private nature. If there is private nature, there is conflict of laws. But if it is public nature, the conflict of laws will not govern here. The third point is that basically a national law made by each country. It is basically national law made by each country. It is a national law because it governs its own nation, or it governs for his nationalities. Its nationality. So it is basically called a national law made by each country. The third one is called national law made by each country. The fourth one is conflict problems arise at both international or intrastate and national level or interstate conflicts. Example, federations. The conflict problems arise at both international. You have to understand here that the conflict problem may arise at one country or at different two or more countries. So if it is arise in the same country, especially for federation countries, example Russian Federation, interstate conflict, it is called interstate conflict. But if it is occur in different countries, two or more countries, or intrastate, it is called intrastate. So this is the main point: interstate and intrastate. You have to understand the nature. There is more than 4 concepts here. The first one is they cannot give substantive remedy. They are indicators or they are directions. The second one is it cannot govern public cases. The third one is they are national law made by each country. The fourth one is conflict problems arise at both internationally or nationally. You have to understand this. When we go to the scope of conflict of laws, we will have this. According to traditional view, there is 2 views: the modern view or the no view, and the traditional view or the classical view. Conflicts mainly deal with 3 major subdivisions. You have to understand this. The first one is judicial jurisdiction. They may be arise. The conflicts may deal about judicial jurisdiction, which jurisdiction shall be govern the case. The second one is choice of law, the law which related state government's case. And the third one is recognition and enforcement of foreign judgments. We will discuss in the next portion, especially the chapter 3 talks about choice of law, chapter 2 talks about judicial jurisdiction, and chapter 4 and the next chapters talk about recognition and enforcement. So we'll discuss them, but when we talk about judicial jurisdiction in the first point, whether it is about whether the forum court has the power to see and decide on the case. If it has a power to decide on the case, we will give the power to entertain the case to him, the judicial jurisdiction. We will discuss about it in the next videos. So the second point is choice of law, the law which related state governed the case. It's the law which related state governed the case. And the third point is recognition and enforcement. We will see in the next portion. The other main point here we will discuss about it, that reason deter of conflict of laws, which means why do we need conflict of laws, or what is the purpose, what is the objective, what is the advantage of conflict of laws, or why the reason that we will have a conflict of laws. There are two important factors relate obstacles to smooth operation of law in international community and give rise to conflict of law problems. The two problems that arise due to conflict of laws, or that the advantage of conflict of laws will arise, are the first one is here. Different legal communities have different laws, or diversity factor. It's called a diversity factor. Or if different legal communities or different societies have different conflict of laws, or different types of legal laws, or different laws, it is called diversity factor. The main reason that we have conflict of laws is that this is a diversity factor, or different legal communities have different laws. This is the main point. And the second point, why we have conflict of laws, is that integration factor or legal transactions are somehow connected. They are connected. The legal transactions are connected with more than one legal system because of cross-border commercial family relations. As there is now a globalization, it has advantages and disadvantages. It creates conflict of laws problems, but it facilitates commercial activities, it facilitates the development of a country. So legal transactions are somehow connected with more than legal system because of cross-border commercial family relations, as they are occurred in different scenarios, especially when two or more countries when the citizens of two countries married each other. So integration factor will occur. When cross-border commercial activities are applied, integration factor will also leave. This is the main point you have to understand. And the next portion we will discuss is that what would happen if there were no conflict of law rules. If there were no conflict of law rules, what will happen? So we will see it. International legal transactions will be greatly impeded. Forum shopping will be rampant. So we will discuss this in detail. The main point is, if there is no conflict of law rules, the transaction will be affected a lot. The transactions, legal transactions especially, will be affected a lot. Forum shopping is making use of judicial options to affect the outcome of the lawsuit, provided that all courts would always apply their own laws. So this is the meaning of forum shopping. This is making use of judicial jurisdictional options to affect the outcome. If I am a citizen from USA, I want to be governed by my own laws. But if I made a conflict with someone from France, the person from France may want to be governed by French law. So conflict of laws problems will occur here. So international legal transactions will be greatly affected, and forum shopping will be rampant. It will be rampant. So this is the first one problem that will be occur if there is no conflict of laws. The second point is that lex fori would always be applicable. The lex fori and lex causae we will see in later portion, in later video. So lex fori would always be applicable. The third point is that no one involved in multi-state legal relationship would be sure of the outcome of his action. If I made a transaction with a person from Kenya, or a person from France, or a person from Russia, if I made a transaction with a person from Russia, I may not know the outcome of my actions if there is any error that leads us to litigation purposes. So no one involved in multi-state legal relationship would be sure of the outcome of his action. This is the main point. The fourth point is that prevention of injustice to the parties. Prevention of justice to the parties. The name change this to justice. It says injustice, but change to justice. Prevention of justice to the parties. Individuals could be gravely harmed, for they may lose a right over status legally obtained in one state when they cross border to another state. If a crime from Uganda, if the crime from Uganda is not a crime for Kenya, this may create a problem. Okay. So it may prevent justice to the parties. The fourth point is that judgment creditors, you may know judgment creditors from Civil Procedure Code. You may refer them from Civil Procedure Code. They are creditors that the case is decided for them, the judgment is decided for them, and the debtor or a person who has obligation to pay something will pay to them. They are called judgment creditors, may be left without execution of their right obtained in one state against defendant in another state. So without execution there may occur a problem of non-execution, or judgment creditors may left nothing, the judgment may not given to them. So this is another problem. And the final point is business and investment will be greatly hampered or affected or devalued or affected. So business and investment will be greatly affected if there is no conflict of laws rules. You have to understand this. And the other point we will discuss here is that chapter 2, judicial jurisdiction. What is judicial jurisdiction? Theories about judicial jurisdiction and the other points we will discuss here. But before we will move to chapter 2, the time is a lot to you. You may be discouraged, or you may be not attended well if I add from this time. So I prefer to do another video for chapter 2. So we will meet in chapter 2 in the next video. So see you for the next time. In order to have the next videos, please make subscribe and share to your groups, your classmates, or the one who loves you. See you for the next time. Bye bye.